to speak? If not, let's go to the first opponent, please.
Mr. Chair and members of the committee, I'm Dallas Erickson. I represent Montana Citizens for Decency Through Law. We ask you to table this bill. We recognize that the Supreme Court has ruled part of the Deviate Sexual Conduct law unconstitutional, but we consider the Supreme Court's ruling as a usurpation of the legislature's right and duty to address the people's will. Our organization filed an amicus curiae, or friend of the court brief, in the Greisen case, and we'd like to read to you a short quote from that brief that was filed by our attorney, Stuart Bradshaw. The statute under attack is one of the oldest criminal statutes in Montana law, deeply rooted in the values and societal attitudes of the citizens of the state. These values and attitudes are reflected in the legislatures elected to represent the citizens of this state and in the laws which they enact or perpetuate. The issue before the court, the constitutionality of 45-5-505 MCA, is a significant political, moral, and public policy issue. In the hearings in this attempt, end quote, in the hearings of this attempt over the many years, we've heard since 1989, the proponents, almost without exception, and I see it's true today, claim that the Montana Supreme Court in Greisen threw out the laws found in that section. That is not true. In fact, the court indicated that some of the law should stay intact, as they wrote just before signing the opinion. Quote, nothing in this opinion should be construed to countenance non-consensual sexual activity, sexual contact with a minor, or any form of sexual conduct for commercial purposes, end quote. And that was in referring to the Deviate Sexual Conduct statute. They wrote that such activity, deviate sexual conduct with a minor, in a rape or in certain commercial purposes, should remain and not be countenanced or allowed under the law. Montana adopted a sodomy law with a common law definition as soon as the territorial legislature met in 1865. It has been on the books ever since. In order to get acceptance of their deviant lifestyle, homosexuals and their supporters had to get rid of all the laws against deviant sexual conduct or sodomy all over America. Virtually every state had a law against sodomy. Some of them made sodomy between a husband and wife illegal. Although the homosexuals and their supporters deny that they have an agenda, this has been on their agenda for years. The people did not vote out these laws, but by the tyranny of their power, the courts throughout America ruled that the laws were unconstitutional. It is interesting that our founders had such laws in the colonies, but as we slouch toward Gomorrah, the term deviant sexual conduct has become a problem for the homosexuals as they work to get their lifestyle choices accepted by all of us. One reason they have to do this is so they can teach this type of sexuality to our youth in schools. If it is still illegal and referred to as deviant sexual conduct, it is harder for them to teach such conduct. Conduct that they claim to be as normal as the sexual conduct we were created to be involved in. As a law enforcement officer in Lincoln County, I arrested several homosexuals who molested young boys in a deviant manner. This law can still be used to charge men or women with deviant sexual conduct between themselves and a minor, or in the cases of rape. The court only addressed consenting adults in Greisen, so the law is still good and should remain on the books. In my opinion, deviant sexual conduct on a minor creates additional harm to that child and should be available for an additional charge besides statutory rape. If any of you think of recent cases of school officials, sports officials, Catholic Church, when they've had deviant sexual conduct with minors, the damage to those minors, to those people are greater, and they struggle with things that the others don't. And I think this should be another tool for law enforcement. We ask you to leave it on the books for law enforcement. This law has been used in recent years. since the Greisen case and should be available now and beyond. There is a bill being written that would simply remove consenting adults from the present Deviate Sexual Conduct law, a simple exclusion from being used against consenting adults without all this other stuff having to change. We have offered that as an amendment to their bills over the years, but they don't want that. They want deviant sexual conduct removed from the books, even though it is not unconstitutional, as you've heard everybody say here today. It is constitutional when used only in those areas I mentioned. This bill that's being written would preserve the advantages of keeping this law, at the same time removing the wording that the Supreme Court has ruled unconstitutional. I'd appreciate it if you'd table this bill and consider supporting the bill that will be coming up from the House. Thank you.
Lawmakers are tackling a controversial bill relating to homosexuality. Today, Senator Tom Facey of Missoula presented his bill before the Senate Judiciary Committee. Under Montana law, deviant sexual conduct is defined as sexual intercourse between two persons of the same sex or having sex with animals. Facey's bill would strike the language which criminalizes homosexual sex.
And those few and simple words in the Montana Code, inculcating your gay and lesbian friends, neighbors, family members, and colleagues with those who molest animals, do matter. They matter to us.
The U.S. Supreme Court and the Montana Supreme Court have both already ruled this portion of the statute unconstitutional, but social conservatives have historically blocked legislative attempts to clean up the law.
The statute under attack is one of the oldest criminal statutes in Montana law, deeply rooted in the values and societal attitudes of the citizens of the state.
Opponents to the bill say the law needs to stay on the books so the state can prosecute those who rape children. However, the Montana County Attorneys Association supports removing the language because they say there are other laws which prosecute rape.
Members of the
Montana lawmakers heard testimony on a proposal to pull a state law from the books criminalizing gay sex.
The law is obsolete and was struck down by the court in the 1990s. More than a dozen supporters of the proposal testified in front of the Senate Judiciary Committee, saying having the law on the books is hurtful and that it is time for it to go. Two opponents spoke, though, arguing that the law should stay and that the courts got the decision wrong.
The statute under attack is one of the oldest criminal statutes in Montana law, deeply rooted in the values and societal attitudes of the citizens of the state.
Words do matter. And those few and simple words in the Montana Code, inculcating your gay and lesbian friends, neighbors, family members, and colleagues with those who molest animals, do matter. They matter to us.
Similar bill made it through the state Senate 2 years ago, but died in the more conservative state House.
Also in